Hey folks, Greg Siskind here. There's already people joining us. There you go. I'm joined by Johnna Main Bailey, who is my law partner, and she runs litigation at Siskind Susser. So she's very involved with impact litigation. She's very involved with individual cases, and then she just does like plain old regular immigration law too, aside from that exciting stuff. So Johnna, thanks for joining this week. And I figured since we had Johnna, am I frozen?
Like you are frozen, for me at least.
But you hear me.
I do hear you. I hear you perfectly fine.
Right, let me remove myself and add myself back in. This very strange. Okay, hang on.
Just me, guys.
Oh man.
Now we see nothing, Greg.
Oh my goodness. All right. Well, Johnna, maybe it'll just be my voice and I'll interview you.
That's okay. Your voice is the exciting part.
I do not know what's the problem on here. Maybe I'll try one more time. Now it's like even worse because you can't. I don't even have I'm not even frozen. Just a second. No. Okay. Well, we'll do it this way. For now, you'll get to hear me. You won't get to see me, but it was very strange. I have to I'll look in my camera and find out like why that's happening. But Johnna, we have plenty of stuff to talk about. And since they don't want to see me, they just want to hear me. We should be able to cover. So Johnna, when we were talking about it, sort of, I think the one that's probably most people are not paying attention to it. The media has covered it a little bit, but this BIA news, hey, there
You're back.
Live stream. You never know what's going to happen. The BIA, the Board of Immigration Appeals, they kind of had some stunning news this week that is going to have potentially big implications for the immigration system on different levels. So what happened at the Board of Immigration Appeals, and why is the immigration bar kind of freaking out?
Sure. So this was an announcement. It was the end of last week, and I'm struggling to remember if that was Thursday or Friday. Greg, it seems like every time I'm on a live stream, I'm just complaining about how we're losing due process. And yet again, this is another example of a policy that's trying to shortcut respondents' ability to have due process through the immigration court process. So this Board of Immigration Appeals proposed change in regulation is just that. So we have the Board of Immigration Appeals, which you only reach if you have completed a case with the Executive Office of Immigration Review or Immigration Court. So if you are an individual in immigration court, you have lost your case, you have the opportunity to appeal within the immigration system. And the proposed regulation is to take your notice of appeal and within just the context of that notice, decide we don't wish to hear the merits of your appeal. And not only is this stunning, but for those who don't practice within the context of immigration or specifically BIA appeals, that form to complete your notice to appeal, you are given maybe one paragraph worth to summarize the basis of an appeal. So it's true. Most practitioners and government attorneys as well get pretty creative of trying to shove your arguments in a very limited space. And, you know, having a panel of judges deciding the case is not worth reviewing on its merits based on the very limited number of sentences you can shove in this very small form box is really stunning. And again, I think shortcutting people's ability to have due process.
Right. So, I mean, I'm looking at some of the information on this, these changes. So for one, you've got only 10 days instead of 30 days to ask for an appeal, which for a lot of people, it's like, especially people that didn't have representation, going out and finding a lawyer that can help you with an appeal. I mean, this, first of all, you should have representation. If you're in removal proceedings, you should get a lawyer. But that's even, you know, even if you get with it later on and you decide you want to have a lawyer, that's not a lot of time to get a lawyer and get that BIA appeal filed. Also, this was sort of like a little shocking, but now I guess the default outcome is supposed to be a summary dismissal. And that's supposed to come within 15 days. Well, and it has to be a majority of board members have to agree within 15 days to accept the case. Otherwise, it's automatically dismissed, which also seems like it's a not a lot of due process there, where there's completely rushed to make a decision on taking it or not. But I saw something that it was something like 90%. This is going to potentially cause like a 90% reduction in approved appeals on there. I mean, it's pretty massive what they're talking about. And Johnna, what happens? Are you out of options when you lose at the BIA? What is your next option?
So the BIA is the end of the immigration court system. So if you've exhausted your appeal within the immigration court system, you could remove your case.
And Pam Bondi is now out of the picture. So she's basically just a reminder that immigration court and the Board of Immigration Appeals are all employees of the Department of Justice. So they all report to Pam Bondi. Is that accurate?
Yes, that is accurate.
Okay. Who was stunning today in Congress when she was answering questions for Congress about all the I'm being facetious about that. I mean, it was just like she's basically just yelling at members of Congress who are supposed to be she's the witness and she's yelling at them. But anyway, now you're out of DOJ land and you go where?
Then you can pull it into district court. So
the district court or is the Court of Appeals?
I'm sorry, you're right. Court of Appeals. I meant federal court, and I'm confusing.
We're in district court a lot of things. That's right. Well, that was sort of the point, though. It's like that. I never understood why that was the case. Why they go right to the Court of Appeals, because that's like one step below the Supreme Court,
right?
And they're pretty busy. The Court of Appeals.
Well, and that's the concern, right, Greg? Because the purpose of the BIA summarily dismissing these appeals is, wow, we're going to clear out this backlog. But what is that really doing? What it's doing is going to create this huge backlog within the Court of Appeals to now have
a lot of judges hostile to the Department of Justice for doing
absolutely.
This. I don't know that it's going to necessarily help their cause if their cause is to try and keep the deportation machine moving. Although I guess the appeals courts just have a limited, limited capacity too. But this is going to overwhelm the appeals courts, in my opinion. If you're talking about massive reductions in BIA appeals, and there's a lot of stuff that immigration judges get wrong that are fairly reasonable appeals to make, and to say you're going to reduce that number of that's not going to reduce the number of errors by immigration judges. All that's going to do is push the adjudication up to the appeals court rather than
exactly.
the BIA.
And I think the other concern is if there will be a discriminatory effect, in the sense that the government can also appeal. My only case pending with the BIA is a case in which my client won his asylum case, and the government appealed the immigration judge's decision to approve. So it's curious. I don't know how much that will be tracked, but will the government's cases be delivered right to the panel of BIA judges for review, or will those similarly be dismissed?
Yeah, and I'm like looking at these statistics, and they're crazy. The backlog at the BIA has gone from 37,000 to 203,000 pending BIA cases. That's a lot of cases. However, I was just telling you beforehand, I discovered just how many decisions and BIA's decisions. I thought there would be a couple thousand BIA decisions out there, and I've been getting asked. I wear the software hat as one of the hats that I wear, and a lot of folks know that I'm a Visa AI founder, and one of the big things that I do in my role with that company is to work on making our library the best immigration law library on the planet. And I've had over the last 2 years a number of requests from people saying, "Can you get the unpublished BIA decisions there?" There's a couple thousand published and precedent BIA decisions. We've had them in the software, and the only way that you could get the unpublished decisions was to actually go to the BIA and photocopy the decisions, a lot of which are sit in notebooks and bound volumes. Um, and I was amazed of good news, which was that they have now scanned everything and they are making it and they're making it available now without having to show up in person and do all that photocopying. Can you imagine how long it would take to photocopy 200,000 of these? So I'm in the process of working with our development folks this week of getting all 200,000 of those BIA decisions into the AI software data set. And it's still, we had to build a tool specifically for this job because it's, to automate the thing, because you can't actually have somebody manually uploading into our data set either, one of those one at a time. But that, I think, is going to be pretty helpful for people, lawyers that are trying to research these cases, to have all of that finally available to them. There's a really good lawyer named Ben Winograd who's in I forget which nonprofit he's with, but he's in DC, and he for years has been the guy that photocopies them and sells an index basically and pass them in a database. And he's the one who tipped me off. It's like I asked him, it's like, we really want to get your stuff in, and he goes, "You don't need me anymore."
Well, I was about to say, for years, that's how I had access. Was I paid a monthly subscription to get on his email list to once a month read through all the BIA.
Yeah, I mean, honestly, I don't know if Ben was like. I mean, he still is going to do that index, I think, but it's like a big job probably for not. I don't think Ben is like retiring on the revenue for that. Maybe I'm wrong, but thankfully that he's done that. But Ben, anyway, so thank you, Ben Winograd, for letting me know that the BIA had just put that up, and that's going to be something hopefully that a lot of immigration lawyers will benefit from soon. Now that they'll have all that in the library. So anything else on BIA? Well, there were some, when we were researching this, there's also sort of been this trend for the last couple of weeks of some really nasty BIA decisions that have come out. And, question was sort of, did it get a lot worse in the last few weeks, or was it sort of in anticipation of some of the stuff that we're seeing? But, one that I found to be particularly cruel is this matter of Yadav from February 5th, so last week, barring where if there's a valid marriage to a U.S. citizen, but it didn't take place until after a final removal order, which may have been a removal order in absentia that a person didn't even know had happened, that is no longer going to be an exceptional situation. That's going to allow a judge to reopen the case. And I can just see really horrible situations where people are in that situation and they have kids and and they're married to a U.S. citizen, and they would otherwise be eligible to adjust status if they can get the judge to reopen on there. That was from last week on there, that was a BIA decision. So some of these cases deal with fairly serious issues. There's another one that's from mid-January about notices to appear not automatically invalidating in absentia orders removal if the hearing notice was not, if a subsequent hearing notice was provided. And there's been a lot of decisions over the last few years about defective notices to appear, and that that's one I have a feeling, like the Supreme Court, for example, is like, how many ways do we have to tell you that you can't revive, you can't do that with defective notices to appear to make them suddenly effective again.
Well, and I think what's interesting about that is the correcting agency in that case is the court. it's not DHS who had the deficient NTA to begin with. So that's
Yeah.
always been my issue. I think the Supreme Court decision on this came down in 2018, and there's been wild case law in the various circuits, and now BIA speaking to that piece. And I don't practice in the removal court setting anymore, but I'm so curious what if the Supreme Court will take this up and like kind of clarify their decision from 8 years ago.
They did. The Supreme Court did just say that they are taking a case. They're having oral arguments on a, well, maybe that was today. There was a green card moral turpitude case, Bondi versus Lau. Oh, no, it's for the April calendar. The news was from today, but it's the arguments are going to be in April. So the Supreme Court, the Supreme Court usually takes what did you say, like 2 to 4 immigration cases a year. They only do 150 cases for the whole year. I mean, some of the stuff is the shadow docket is more where, they don't really issue a decision, but they do things that affect immigration. But this is a honest to goodness oral arguments for a case the Supreme Court is going to hear. Bondi versus Lau. It's going to determine the evidentiary standard the government is asked to meet to deport a lawful permanent resident who committed a crime of moral turpitude but was later allowed to re-enter the country. So I think it's going to have to do with what the standard of proof is at the time that they re-enter the country. Anyway, it seems like a fairly obscure issue that probably doesn't come up all that often. But I was a little surprised that of all the issues, controversy in immigration law, that's the one that they pick, which probably affects not a lot of people. But that, on the one hand, it was like, it was sort of like, that's a little obscure. On the other hand, it's like, yeah, take the obscure ones on there because you're probably going to issue bad rulings. And at least if you do it on these things that don't affect a lot of people. But, we will see on there. So we'll talk. There's a couple other cases this week, and we're going to talk about some business immigration stuff too. So I know a lot of you guys tune in to hear what's going on. We're going to talk about the H-1B case in a minute. But the other case that kind of had a lot of people shocked, and this one did make the national news in a big way, was this Fifth Circuit decision regarding bonds. And so, Johnna, what did the Fifth Circuit do, and why? And I guess the question is, has anybody else done anything like that yet?
Not yet, but there has been a trend within immigration court to limit bond options for those who entered without inspection, meaning don't have a legal entry into the United States. So when they are detained, the presumption is bond is not available to them. And the Fifth Circuit affirmed that, unfortunately, saying bond does not have to be an option. It was reasoned under, and this is like kind of gets technical for those who don't practice. Maybe it's not as important, but it's reasoned because those who did not present themselves for a lawful entry who are now in the United States are presenting as arriving aliens. So it's kind of creatively arguing and saying that they're excluded from the option of bond, in the sense that even though they're in the middle of America and maybe they've been here for 2-3 decades, they are quote unquote arriving aliens, and on that basis aren't eligible for bond. So this is an issue that we're facing nationally, but this is the first circuit court to step up and make a decision, and obviously a massive loss for those who maybe aren't within the Fifth Circuit. You also
what states are we talking about? The Fifth Circuit?
So that's Texas, Arkansas, and I think the circuit
Louisiana
line includes Louisiana, and that's the kicker, because even for those outside of the Fifth Circuit, a huge majority of the country are still being transferred to the detention facility in Louisiana, which means the judges in those immigration courts are bound by that circuit court decision. So it probably has a bigger impact than, what you would generally think of as a Fifth Circuit decision.
Yeah, I mean, I think some judges have been trying to prevent that from happening by issuing orders to tell ICE that they are not allowed to transport the person out of state. until they have had their, habeas, and they've done, they've had all that. So I would imagine now that's going to become as soon as somebody is detained, they're going to, a judge, they're going to have to go immediately to court and get a judge to stop the transfer. Although I would guess they can still order the person to be brought back to them. And once they're, so like if you're in Minnesota and the judge says, I don't care that you are in Texas now, ICE, that you sent this guy to Texas, bring him back to my court.
But
don't have the hearing here. And
didn't we just have the Minnesota judge throw a tantrum, and justifiably so, because it takes 48 hours for the person to be transferred to Louisiana, and it took 13 days under a court order to bring the detainee back to Minnesota.
Yeah.
So, yeah.
So anyway, that's what we're going to see more of this, this fighting between the DOJ and the judges on there. And I don't think the Fifth Circuit is going to necessarily be all that well regarded by the rest of the judges around the country after this. Okay, so let's skip a little bit. I think we had some other things on the list, but let's talk a little bit about the impact cases. So the one I know a lot of people are, they're asking about a lot of different cases, but the H-1B case is coming up very soon for oral arguments. The news on that case is that we have a 1 week delay in the oral arguments versus what it was originally scheduled for. It has to do with the government asked for the extension. This was sort of a compromise. They have a motion to dismiss. We have a preliminary injunction motion. So everything should work out along the same schedule. But we're looking at February 26th now for the arguments in San Francisco on that case. This is the only oral arguments I think that have been scheduled. I don't think the chambers has been scheduled yet. They fully briefed their appeal to the DC Court of Appeals, and it was a pretty good brief, if you ask me. After looking through it, I was pretty pleased with it. But so I'm hopeful, and they also I think have the draw that they have for the three judges, I think, is good on there as far as fair, judges. I think that'll give it a fair hearing. And then the third case, the Boston case, that's the California versus Nome, that is being argued in Massachusetts, which I think is kind of funny. But basically, these are the 20 states attorney general, basically blue state attorney generals, who are suing on the H-1B $100,000 fee in Boston. They do not have a preliminary injunction motion in their case, and so, but it is. I believe it's to the briefing schedule is such that it's going to be sometime next month. I think that we're probably going to see arguments there. We have this looming H-1B lottery that's coming up, and a lot of people are like wondering whether we're going to have clarity by the time the H-1B lottery happens, and we might. What I am suggesting to employers is that you file your cases in the H-1B lottery as you need them, because if we are successful in our case and you haven't, and we don't have a decision by then, the $200 that it takes to file a registration, you're gonna be kicking yourself if we or the other two cases get a good result and then you didn't file. And I know there's like a lot of employers just like, I'm not doing anything until we have some clarity here. But you're not obligated to file the H-1B application. You're not obligated to anything on fees other than the registration entry fee. So if I were employers, I would go ahead and do that. There is a weird loophole, but I'm sure the White House is going to deal with it. But you have actually the order expires on September 21st. The H-1B start dates are October 1st. So the administration is going to have to do something of extending, and they're going to have to change the order where it said you had to be in the United, if you were in the United States before September, it didn't apply. But we'll have to see what the administration is going to do. My guess is that they're probably going to extend the order when at some point. But as of now, this thing is over in September. But I can't imagine that if they win this suit, I can't imagine they're going to get rid of it anytime soon. But maybe, you never know. On there, I mean, there's a lot of employers that have influence with the White House that are still mad about it. I think a lot of these employers, it's like that have the presidency or thought that this was like good for them because they just like, we don't have that many. We only have 20 H-1B employees that work for us, and we can pay $100,000 each for them, not realizing that they have large numbers of H-1Bs that work indirectly for them, through contractors, and that's and the contractors are the ones that are getting destroyed by this. And also the new H-1B registration rule regarding lottery entries is going to hit a lot of those companies as well. And that's, there is litigation that is being discussed, but that's one I don't think I think there's zero chance that we're not going to have this new system in place for the lottery, where you get basically 4 entries for a level 4 wage, 3 for a level 3, 2 for a level 2, and 1 for a level 1 wage. That I think is pretty definitely going to happen, just because it's at this point, they're not. I don't think if you file something now, the odds of stopping something by March 4th are pretty low. I hope I'm wrong on that, and I hope somebody files it shortly. But I think employers need to basically assume that that's going to be the case this year. On the other hand, between that rule and the $100,000 fee, I think the odds of being selected in the H-1B lottery are probably better than ever. Just because I think a lot of people are, a lot fewer applications are going to be going in for registration than in years past. So this could be your year if you file or this could be the year you get your raise, because employers, I think, are going to have a big incentive to try and get people up to a higher wage level, which I guess is what the intention was. But it's not a very sort of a sledgehammer way to get to that. Not a very strategic way, and they don't make any distinctions between occupations or anything like that. So you can be level 4 in the lowest paying of any occupation, and you could be level 1 spinal surgeon, making six, I don't know what the level 1 wage is for a spinal surgeon, but it's a lot of money on there. But it seems kind of strange that, level 1 for somebody like that is going to mean they have 1/4 the chance of somebody who is level 4 for a position that they're paid a fraction of the higher one. So I have a feeling we're going to see some strange outcomes. But that's the H-1B case. So Johnna, tell me what's going on with the travel ban related cases.
Which travel ban, Greg? Because it turns out we have 3.
Well, tell us about all 3 of them, since we're litigating all 3 of them.
We are litigating all 3 of them. So it's actually technically 2 travel bans.
Some of our friends at other firms are litigating them as well. So there's a lot of activity in this space.
And we are all rooting for each other, right? Yeah. Because
I can tell you, we're all helping each other behind the scenes, coming up with we're sharing documents that the government's giving, helping shape arguments in the other cases. It's not I think that there's this perception that we're all we're rivals to some extent, but we're all friends too. So it's not, it's pretty amicable overall.
Exactly. We're all like having separate suits, but all against the same defendant, in the sense that if anyone is able to strike down the policy, it's a victory for all of us and really the whole immigrant community. So in terms of the travel ban, The first is this 35 country ban.
I'm sorry.
And
Sorry,
yeah,
go ahead.
we'll get to questions. The 35 country ban, we have split into two distinct lawsuits because the way this is impacting applicants and immigrants is in two different ways. The first is something that we're calling a USCIS benefits pause. And this is basically having USCIS stop adjudicating all applications, all petitions for those from the 39 country ban list. So this includes like I-130s by US citizens petitioning for their spouse who maybe happens to be from the ban list. This includes every single type of immigration application and petition. Makes it a huge ban. It also makes it an ambitious lawsuit. Ambitious, but probably more likely to win for that reason. So that lawsuit has been filed by Impact. We chose the Northern District of Georgia. So we have
there was a reason for that.
There is a reason for that. So we had several jurisdictions or venues that we were debating amongst, and one of those was Massachusetts. And our colleague Jim Hacking filed his lawsuit there. We're rooting for you, Jim, but we did not want our case related. We strategically wanted to be in a venue distinct from other national lawsuits. So yes, we consider.
But it may be related to another suit in northern in Georgia, or we may end up with the same judge that we had several hundred of our F1 students when they were going through their visa revocations. We did it there, so we have had. I mean, I don't know if it'll be any. We'll get the same judge and all that, but we do have we have some success now in Georgia. In Atlanta, and that was that was when we were thinking about this. That was a reason. It was a big win for the students in 2025 that we had. So hopefully we'll see something similar with this new case. That's one of the cases.
One of the cases. So the same travel ban impacting the 39 country is also for those who are outside the U.S. applying with a U.S. consulate, which is under the Department of State. So that is a distinct lawsuit that we have filed in D.C. because that's the headquarters for the Department of State. And I want to jump ahead to talk about the 75 country ban because I see a really interesting question, Greg, if you want to put that one on the screen by DKJ.
Oh, DK. Yeah, I'll put it on.
Yeah, so it's an interesting question. Let me first give some context for the 75 country ban. So the 75 country ban is some overlap from the 35 country ban list, meaning some individuals are facing two distinct travel bans, and they're on different bases. So the 75 country ban is distinct from the 39 country ban in the sense that it only impacts cases for those applying outside the United States. So to that question is, have we seen adjudication of applications meeting at USCIS for those who are part of the 75 country pause, but not part of this 35 country ban? We have not seen, we have seen adjudications. We have not seen any negative impact from USCIS cases. And again, that has to do with the fact that the 75 country ban is not related to USCIS. It doesn't mean that there's an adjudication pause. It's very possible USCIS may announce that policy change, in which case we will be onboarding for another lawsuit. But I think another part of that is for those who are on both travel bans, it creates this issue if you're applying at the consulate in the sense that you are up against two distinct bans. They are issued under distinct regulations of law, so you're going to have to overcome both of those. Similarly, if you're one of our plaintiffs for Impact, you really need to think about being a plaintiff for each to remove the travel ban from two different bans, if that makes sense.
All right. I'm going to show something in a minute as well. When you're done about this, just an exchange that happened today in the Senate regarding the adjudication bans, the U.S.
Oh, sure.
The benefits pause.
Well, let me wrap the 75 country ban with this. We are still onboarding for that lawsuit. We had planned on wrapping up onboarding last week with Impact. We haven't had as much interest in the lawsuit as we had initially thought, so we have extended onboarding. So if you or your family members are impacted, that is still open. There is also, like, you can join a list if you want to be contacted in the event that we do open up plaintiffs for the 35 country ban litigation for either
39.
one. 39. I'm sorry, my numbers get confused because we have gone all over the place. It started at 19. It's my memory is failing me. But we have an interest list if you want for us to reach out to you in the event that we can add plaintiffs in the future. But at this time, those are filed and pending cases.
All right, let me take that comment off, and now let's see if I can do something high tech. If I can get this to work. Hold on. All right, so this is, let me see if I can get the volume to work on here. All right, so let me go back. So this is today, David Beer. I'm gonna play the whole thing because I just found it very fascinating that this is a Republican senator, John Kennedy, who's a physician. He's a bright guy. He also has been sort of known to be one of the few Senate Republicans who occasionally will go off script and criticize the president. But he's asking David about the adjudication ban at USCIS that we've seen on the in the 39 country cases. So let me see if I can get this.
Hey, Mr. Beyer, am I saying your name right?
Can you hear it, Johnna?
I can.
Okay. All right.
I like beer better.
Most people do.
Tell me that I think I heard you say that some people, some folks who've come to our country and are trying to get status to stay, have applied to the Department of Health of DHS, and they've paid money, and DHS is doing nothing.
Oh, that's right. Yep, they're sitting on their applications, not processing them.
That's a pretty bold statement. How many people? I'm not saying you're wrong. I don't know. How many people we're talking about?
About half of the immigrant flow right now.
So
90 countries are affected by the State Department ban.
How many people is that?
Well, it's at least 300,000 abroad, and probably twice that when you consider the people already in the U.S.
So 300,000 folks have gone to DHS to seek some kind of permanent status or semi-permanent status to stay. At least 300,000, and they've paid money to DHS, and DHS has done nothing.
That's right. Yeah, they're sitting on their applications.
Well, who at DHS is
putting them in the trash?
Who at DHS is doing this?
Oh, it's Joseph Edlow. He's in charge of it. He came up with this policy to just.
Who is he?
He's the head of USCIS. Joseph Edlow is the head of USCIS.
This is today,
DHS.
Where he is just.
Slow down a minute, man. You've had too much coffee. Is he he's at DHS?
I'm just from New Jersey. So.
I understand. Great state too. Who does he report to?
Secretary Noem, of course.
Okay. Does Secretary Noem know whether this?
I don't know what Secretary Noem knows, but she's aware of the general tenor of this administration.
What's his name?
Joseph Edlow.
Mr. Edlow. Who's his boss?
Secretary Noem.
Oh, okay. And you can document all this?
Oh, absolutely. They put out a memorandum saying we're not processing these people. And Secretary Rubio is involved as well when it comes to the State Department.
Would you send me that memo, please?
I will absolutely send that to you.
I went way over. I'm sorry.
All right. I think that's enough of Secretary Kennedy. You get the gist on it. But, this is the Senate is, I guess they're doing oversight. That's like what their job is. And Senator Kennedy seems like the first Republican to take an interest in the fact that hundreds of thousands of people are basically having their money stolen by USCIS. who's collected all this money and may never actually do any work on any of these cases, and certainly doesn't seem to have any interest in coming up with with refunds. Premium processing fees, I can promise you that they're not going to be refunding people who had those applications pending. But I did think it was, interesting that it's sort of like once you get the attention of some of these Republicans, they seem to be. I mean, he seemed to be genuinely shocked that
Right.
this happened. So that's good. And we were talking today about getting a transcript of this just to show, potentially add that somewhere in our litigation. Anyway, that's on these bans. I think it takes sometimes a lot of people complaining to. I mean, I'm guessing probably he's asking these questions because probably his staff is getting a lot of complaints.
Sure.
And it's probably percolated up, and he's like, "Well, we're going to be having a hearing on some of this stuff. I'll ask questions about that." Anyway, that was today. So, Johnna, I guess that the other case that we've started onboarding this week is deals with the diversity visa lottery. And what's the gist on that case?
Well, the diversity visa halt was kind of also related to these country bans. So late November, there was the unfortunate incident of an individual who had come to the United States through the diversity visa who, out of an act of violence has resulted in all these negative immigration policies. Right. So no, we don't condone the violence, but certainly these really harsh policies that really impact. You heard the testimony about half of the applicants before USCIS. It has a really harmful impact, not only on our clients, but our country as a whole. So that includes diversity visas, which is really interesting given that Impact has taken up the diversity visa in two different cases. Now it's been, 2022 was our most recent. Is my memory serving me correct on that one, Greg?
Yeah. We did one in the, it was the early Biden administration.
In 2021? So we had the two. The first, I believe, was 2021, and the most recent was Go in 2022. So those were related to just the general delays and failure to issue the diversity visa.
At least had an excuse, which was COVID.
And so
it's starting to become an old excuse, but they at least had something. This administration is just like betting crime, that on there, even though this program is 1990 Act, or maybe the late 80s, the diversity visa was created, and it's like one of the safest, one of the lowest crime incidents of crime of any immigrant population of the diversity visa winners. There's like no evidence that, and they're certainly way lower than the general population, which is sort of like should ultimately like be the reality check. Is like crime is a reality, and there is always going to be a little bit of crime. The question is sort of when you're talking about, hundreds of thousands or millions of people coming in, and you have, you're going to have some crime that happens in that population, but is it making us less safe or more safe? And overall, all these immigrant populations have made us more safe when you sort of factor in the number of crimes per 1,000 people in the United States, or however you want to look at it. The numbers always look better when you add immigrants in versus just looking at the native population.
Yeah. So one bad actor was the justification for the halt in the policy. But again, we've won on this issue twice before. So this case, we just opened onboarding this week. Historically, these have been very big cases. So we're hoping to onboard for the next 2 weeks. We may extend that again, depending on if we're having a big influx of interest on that. We hope to file soon, because the kind of difficult thing with the diversity visa is visas must be issued by the end of September. If they're not issued, you've missed your opportunity. The fact
not a lot of time. I mean, we have to file this thing soon to make sure the courts have enough time to do their thing, and for the agencies to if we're successful, that the agencies have enough time to adjudicate the cases. So if you're in the situation, you should join a suit. Hopefully you will consider ours, but you really should join one, because on your own, I think it's pretty hopeless. And, we might be successful in getting an order that's across the board, but what we've also seen a lot of our cases is where judges will just limit to the plaintiffs that actually litigate. So we never know in these cases what's going to happen. That happened over and over again on COVID bans for us, particularly with K-1 visas. You may recall those cases where we would ask for universal relief, and then the judges would just limit it to the plaintiffs, and so we would just sue again and again and again. But it was for a lot of people, it was just months and months of extra waiting, hoping that they were going to get, that one of these cases was going to fix the problem for them instead of joining the case. And then not, after a while, people figured out that my only option is probably to be a litigant. That being said, Johnna, people can also sue individually on any of these things. And there are good reasons sometimes why they might want to do that, especially if they want to have close collaboration with their lawyers. If you're suing in a mass litigation case, you kind of have to, to a large extent, just kind of sit back and be an observer more than an active participant beyond the beginning of the case, just because there's a lot of people in the case, and that's basically, if you want premium processing, you have to sue for sue individually. And premium processing meaning having the front row seat to talk to the lawyer and talk to strategy and work it through and all that. So there are good reasons to do that, and you do file a number of these cases. Especially on mandamus and others. But for anybody out there who's thinking about wanting to sue over, on something, either to get their case sped up or to appeal a decision, Johnna is your person that you should schedule an appointment with. Johnna, we had a question, and I just double checked the dates on here. So this was a question that our friend DK J232 asked a few minutes ago, and he also asked the age. I
was about to say, DKJ is asking some good questions. Keep those up.
So this was published. This notice of proposed rulemaking on the public charge grounds was published in November, on November 19th, 2025. So it's about 3 months ago, almost, or 2.5 months. The comment period ended January 20th, so a couple weeks ago. The final rule could come at any time on there, and we just know, sometimes they will rush it out, sometimes they won't. They rushed out the proposed rule on the H-1B lottery. They rushed out because they wanted to have it in place by this lottery. The public charge rule, I'm not sure, but I can see this month or next month being when this thing rolls out. Right now, the 2022 rule remains in effect. My guess is there will be a lawsuit filed fairly quickly. By the way, that was sort of there was a reason why the Biden administration went to all the trouble to publish a final rule in 2022, was because you can't, I think this administration thinks you can just overturn any rules you don't like on it. That's not how it works. You have to actually go through the process of showing why the previous rule was inadequate, why and they may try and do that, but a court is going to have something to say about it. And the last time this administration tried to do this, first of all, it was like a 300-page rule that they issued in the first Trump administration, the public charge rule. I haven't done I should just basically ask AI to do it, but I haven't done the comparison between the first Trump administration public charge rule and this public charge rule. I figure when we have a publication date with an effective date, that's when I'll pay more attention to it. But my guess is that there will be litigation But what I don't know if you were with us when the last public charge rule. I don't know. You probably were there.
No, I was. It was during Greengate 2020.
So I took a week off of work to build an app that essentially automated all the analysis on whether you were subject to that 300-page rule.
Oh, interesting.
This was, Johnna, this was with Afterpattern. I know your favorite software lately. Private joke. But it was a great way to actually learn the law or learn the rules. It never actually became necessary because it was enjoined and never the law, the public charge rule from the first Trump administration never saw the light of day. So I don't think I'm going to go through that exercise again, unless we know that it survives litigation. But that was last time. So they're going back to the playbook. They, I don't know, what they think they're going to be saying differently that's going to get a different result from a federal court. But my guess is that it's probably going to be the same plaintiffs and it's probably going to be the same court they're going to go back to. And the court's going to have to decide what's different between what their decision was the last time and what and this time on it. But that is a good question. I don't even want to think about what that's going to mean for these cases. I mean, we kind of know. The only thing I can say that might be useful is this adjudications pause is in theory all based on public charge. That's what they say, that they're trying to it's not just the first one was based on security. This one, they're talking about the Somalis. And
that's the 75 country ban is based on the.
I mean, I'm just saying that they're a lot of this stuff and the benefits pause also, they're supposed to be taking a close look at public charge on there. But in any case, it takes that excuse off the table if we have a new rule in place. But the rule is going to be ridiculous. So I mean, we don't know what the final rule is going to say, but I can promise you it's not going to be anything that people are going to be singing the praises of, unless you hate immigrants, which that's who's writing these rules. But that being said, that's going to be our fun spring, is trying to figure out about the public charge rule and whatever other. I mean, they have quite the imagination, the immigration policymakers at the administration. So I'm sure there's lots of things that we won't predict because we just don't have we can't think like they do as far as being as vindictive. But this is one that's coming up. So thank you for calling that one out.
DKJ's other question about the H-1B lottery. This is kind of a fun thought exercise.
What is stopping an applicant from registering as level 4, winning the lottery, then transfer another employee as level 1 or 2? So there is stuff in the rule that is supposed to take, look closely at transfers and things like that. And if they think you're trying to game, they could deny you on that basis. Now, but it is a good question on there as far as that goes. But I would suggest being conservative. Mm-hmm. And if you went into the lottery at one wage level for a particular position, I would be very nervous about filing a change of employer petition where the next time you're filing at a lower wage rate. But it is worth probably taking a look at the comment, at the preamble or whatever they were discussing it. But I am going to guess that is going to be sort of an automatic request for evidence when they see an application like that being filed. They have changed the questions on the form, so they will see it. At USCIS, what the wage levels were going to be. So I don't think it's going to be that easy to game it, and that's what they're on the lookout for. So I would be careful.
And just maybe to reiterate, there's not a bright line rule. So In addition to, changing in general, even if you're not changing the wage level, you generally don't like if you have an October 1st date, probably you don't want to file a change of employer in November, even December, but especially with such a drastic change in the wage levels. But also more generally, why in the world would you want to go from an employer at level 4 to an employer paying you at level 1 or 2?
Well, I mean, level 4 in New York City might be level 2 in Gadsden,
Fair.
Alabama.
Fair.
I mean, I don't know, but it is or the employer's going out of business, or something's going on, and you have no choice, and you have to make a change, and maybe it's difficult to find a job at the level 4. The only thing also I think would be, the USCIS would say, if like you're such a hotshot and you were qualifying for level 4 and now you're like same position, level 2 on there, did you suddenly, maybe you're, maybe we should not have, considered you as qualified for the first one. If it turns out you're really only worthy of level 2, I don't know. But, I've seen it also where there were people that were, I've been talking about, like, what if I file in, well, it's mostly about just moving locations. You can, if you want to move to another location where the wages are just drastically different, it's not to say you can't do that. You just have to have a really good explanation for it. And it might be that there's a really severe shortage of a particular occupation in one location, and then you go to another location and there's more. But the whole point of this is to raise wages for U.S. workers. So I don't think that's going to be a particularly compelling argument.
Precisely. And I think it also kind of raises the concern of SOC shopping, SOC code shopping, just to find something that hits the sweet spot of a higher wage level. Probably something you don't want to do because,
I can tell you that, there's gaming. There's always been gaming going on in the H-1B lottery since the beginning of time. And it's frustrated me as far as some of the stuff that we've seen. In fact, we had a lawsuit that was all about H-1B lottery gaming from a couple of years ago. And this was the one that we actually, I think, impacted policy in a way that made me happy, which was there was this problem with employers were working with middlemen recruiters and IT entry level folks, and basically they, somebody from would have like 10 employers file separately for them for an H-1B, and they would have 10 entries in the lottery. That was only a couple of years ago that was the case, and we sued over that. And USCIS said, we will fix that, Judge. Please dismiss the case. And the judge, you may recall, we were very upset that the judge dismissed the case because we didn't believe USCIS was actually going to fix the problem. And then they did exactly what we kept telling. I mean, you can go back and listen to my live streams with Chuck, and I kept promoting this as this is the solution to the problem: is flip the lottery. Make it a beneficiary lottery instead of an employer lottery.
Exactly.
And the problem will go away. And then we saw a drop of about 300,000 applications the next year. And so everybody had I don't know if it completely fixed the problem, but I think it did a pretty good job fixing the problem on there. So, sometimes sometimes these, this gaming, they figure out a solution and they're able to stop it. But I think this new multiple entry system is going to create all kinds of new incentives for people to fool around with that, and that's something that I don't think would be a good result. I don't have a problem, by the way, of Congress, which has authority here, not the administration, wants to look at. They've looked at legislation in the past to have a hierarchy, basically, where it was sort of this is a different way to get to the same thing, but Congress in their previous bills would say, this group gets first priority, this group gets second priority. And it would be sort of like advanced degree, PhDs from US schools go first, and then master's to PhD goes, and they would like drop all the way down. And then degree, PhDs from foreign universities are next on the list, and then master's degrees from foreign, and then bachelor's from the U.S., and then bachelor's. So they went down the list there. The problem was, it's sort of, as I'm always at this weird filter where I'm in this outlook where it's like, how does this affect my clients? And I do a lot of work for doctors. Yeah. I always think it's like, how does this affect the doctors? And in that case, they didn't count graduate medical education as a degree, even though they would be spending 7 years, getting becoming a board licensed, surgeon or whatever they were going to be doing on there, and they would still be at the bottom of the lottery. And ironically, that has happened again with this new system where physicians, because there's not a lot of physicians in these shortage areas, they don't have a lot of wages to, they don't have a lot of people to survey. So they use this national wage in a lot of cases for doctors, where they don't have enough people to survey to figure out what the average anesthesiologist is making in this particular location. And those people are going to get one entry in the lottery, even though they are being paid the national average wage for a physician. That's, no, they may be making way more than that on there, but they are considered to be a level 1, essentially, for purposes of the lottery. That spinal surgeon, that's making $800,000 may still only get one entry in the lottery under the way this weird system works. So there's going to be unfair results in this as well. And I'm guessing that there will be doctors that are in whatever lawsuit that's being planned. But until, I think we're stuck with that for this year. So get ready. All right, we are past the hour, and that being said, some of us want to go to sleep. So we'll see you next week. I'll be back. I'm not sure who I'm being paired up with. The following week, I'm going to Krakow, Poland.
Jealous.
Well, Krakow in February is not exactly like, the prime time to be going there, but
I would take Krakow in February over not Krakow in February. But
I'm speaking to a bunch of immigration lawyers from different countries about AI stuff and about what's happening in the US too. So I won't be on that one because it'll be like in the middle of the night for this, but hopefully I won't be missing too many this spring. Anyway, but until next time, thank you guys for watching, and we'll update you next week on what's going on in immigration law. Thanks a lot.
Good night.
Bye-bye.